I am just going to briefly introduce our speaker. We have just 1 hour and it will be as interactive as much as we can get it to be. Nicolas is the CEO of REDEC and has led key electronic dispute resolution projects. He is a fellow of the National Center for Technology for Dispute Resolution, and he'll be sharing with us this how ODR has been and can be used for prevention of disputes. So, Nicolas, you have the floor. Thank you for taking your time to join us today.
Morning, thank you so much for the invitation. Hope you're hearing me well. Okay.
Yes, we can. Yes.
So to me, it's fascinating to have the opportunity to talk to you about something I'm really passionate about, and it's the possibility of going beyond dispute resolution and going into dispute prevention. I believe it's the future of ODR as a whole. So perhaps in the future, we will no longer speak about ODR, but rather ODPR. Prevention and resolution will be both parts and fundamental parts of how we conceive the application of technology in the management of conflicts as a whole. And as you know, this discipline that started out in the 90s, in 1995, with the first pilot by eBay, and later on with many other e-commerce companies, and then later on with some government agencies, consumer agencies around the world, and later on with courts. Well, what we can see now is that ODR has started to become the international standard of what it means to have dispute resolution through the internet. So just 5 years ago, pre-pandemic, we had over 12 United States courts with ODR. And then the number has been increasing all around the world, particularly in China and Singapore and Canada. So there are setting the example of how far we can go with the application of ODR. So what we're going to do is that we're going to present the traditional method, the traditional vision on how you resolve disputes with ODR, and now, well, how is it different to prevention ODR? Then we will head into the benefits of having a prevention approach. Then the third place, we will look into the tools and technologies for preventive ODR. And finally, the challenges for implementing this kind of technologies. So a traditional ODR, and this is the ODR Africa Network, so you really know what it is. It's basically using platforms or using technologies for the purposes of resolving a dispute. So basically, what we can see, it's mediation, arbitration, adjudication, online negotiation, but everything that involves parties having self-composing their disputes, and of course using the internet or tools that will be online. So that's why it's online dispute resolution. So we have the Anthracol technical notes from 2016, and we have principal standards, for instance, those set by the ICODR, the International Council of ODR, and of course the NCTDR, where both Miriam and I have worked in the past. So, but then how is this different? So resolution basically means there's an already existing conflict, and I will use technology just to set it up, to settle it. What we can do with preventive ODR is to prevent, as the word says, to avoid this conflict with the same use of technology. So what I would say is that the discipline or the logic of ODR still applies, but with a different vision, with a different approach. So the focus that we may have seen over the last 30 years on resolving conflicts, with prevention ODR, we're trying to mitigate risks associated to conflict. So how we can prevent conflicts from escalating and into becoming something worse. Imagine if I don't use proper dispute prevention mechanisms, I may end up in litigation before courts, and it will be offline. So you will have to do paperwork, and then you will do the very traditional lawyer kind of work that we are trying to avoid. So the state of the art, what we've been seeing, and I will qualify this as a trend of the last 5 years, is that with the uprising of artificial intelligence, you start to see ODR, intelligent ODR environments. So what you want to do is to get early intervention with contextualized information. So ODR becomes a tool associated to data analytic with the focus of trying to get real-time access to what people are doing in their day-to-day operation, for instance, as a lawyer or as a legal vice presidency, with the aim of, in this case, for instance, protecting consumer rights. So what companies would do is, say, an e-commerce company like AliExpress, what they're trying to do is to reduce disputes, having proactive information of what can go further. So maybe you resolve a dispute, and then it gets red flag of something that may come along in the future. So what I'm going to do with preventive ODR is having this data, this information, and apply it to prevent other customers from getting into a much more escalated dispute. And of course, this will basically mean the integration of ambient intelligence and artificial intelligence. Ambient intelligence meaning having the context or the environment, the ecosystem where those users are interacting and trying to get information out of it to see where the disputes may arise. And of course, artificial intelligence, for instance, generative artificial intelligence with the purpose of having text that will be generated automatically, like and also with the purpose of trying to advise the user, in this case, advise the customer in order to prevent a dispute, in order to prevent a claim or potential litigation. And what are the benefits of going for this preventive approach? Well, I think there are many benefits. I mean, if you change the metrics from resolution to prevention, you are just changing the mindset of the people involved, not only the lawyers, of course. We as lawyers are usually of a reactive nature. So we're always waiting for the conflict to come. When we become more empowered with prevention tools, we are the ones that are taking the steps for that not to happen. And for consumers as well. So if the consumer knows that he's getting a real-time accompanying process from the company to see that there's something not going to escalate, of course, I would be more satisfied. So the benefits are usually those also that will be related to traditional ODR, but those benefits will be maximized with the preventive approach. Let's start with time saving. When you use preventive ODR, you're not only saving money on avoiding the court system, you're also saving money by avoiding the conflict, because only giving attention to the conflict, that's still very expensive. Say you have a customer service agent that you have to pay for in order to call the client, say, for instance, in Airbnb. So if I have to call a client and say, okay, so this is not going well, I think you, as the guest in this house of Airbnb, you're causing damages. Well, you don't want that. You want to give some information, data, to the user and to the platform, Airbnb, that, hey, maybe give this advice to the guest so he will not cause any damages to the property where he's staying. So time saving becomes higher. Also, the reduction of costs associated with litigation. So the lawyer will no longer be reactive and will not only be attending a conflict before the consumer protection agency, as it is the case in Colombia and many other countries, but he will be more focused on trying to improve the reputation of the company. And the success rate, it will always come with how many conflicts we have avoided. And then you see how empowering that is for a lawyer. He is a conflict preventer. He is a person who will be in charge of not allowing things to escalate. And the third major benefit that we can see here, and it also applies to ODR, but with prevention ODR, you preserve a much better relationship. When you have a relationship in the context of ODR, but you already have a claim, or you already initiated negotiations, or you have to go for mediation or even arbitration, the relationship is broken, or at least it's damaged. So what we want to do is we want to prevent this injury to this relationship and to have better relationship with them. So the more data we have, the more company we can keep to the people using the platforms, the better results we're going to get. And of course, this applies across the board to all stakeholders in the dispute prevention and virtual ecosystem. For companies, and I was just giving the example of Airbnb, they will be more profitable. So the customer service agents, rather than being on the phone call every time, there will be more of data analysts and looking into potential conflict and trying to prevent them. So they will not have to use the phone so much anymore. They will have to send those alarms. They will have to have these red flags all the way, trying to see where the disputes may arise. Of course, the consumer is also empowered in the sense that he will be much more involved in the use of any platform, any given platform. It can also apply, for instance, to an Uber platform. So if I know that Uber is trying to give me data in order to prevent conflicts and that I won't have to argue with the driver, then I will have a better rating for the driver, and then you have better also a better outcome for the company as a whole. And finally, when it comes to the government or to the regulatory bodies like the consumer protection agencies, well, they will have less work, because if you manage to prevent disputes, they won't go all the way to the consumer protection agency or to the courts, meaning that this backlog of thousands, or perhaps in Brazil, 80 million cases, well, you will be able to aid in the purpose of not having so many disputes anymore. And then we can see some international examples of how this is applying. In 2021, for instance, we saw how in Spain, 61% of Spaniards bought online from their merchants. And of course, they're all the way more willing to keep the relationship and to be preventive of any potential disputes. 65% of Italians are getting online. In Germany, that's also the case. So the use of online or e-commerce is increasing. And of course, the ODR as a mechanism has to adapt to that reality. If we keep having reactive ODR or resolution ODR, then we will have to invest a lot more money, because we will have many more people using e-commerce and many more potential conflicts. And then let's try, as a third point, to get into the tools and technologies that we can apply to preventive ODR. We have worked, or we can see in the internet, and many of them, for instance, early mediation, mostly automated negotiation with intelligent agents. So as you may have noticed, you're going to have online assistants powered by AI that will help customers navigate in any website or any government agency where they're having any procedure. Also, early warning systems, as I was telling you, those yellow or red flags to see what's going on and where the conflicts may arise. The automated negotiation platforms, so you have parameters of those negotiations and how they can be handled automatically without any human intervention, and also predictive advice, which applies not only to the provider, to the e-commerce provider or to the government provider, but also to the users and consumers as well. But of course, we have to have some warnings about this. I mean, it looks very good, but then there's a lot of work behind it. There's a lot of dirty work that you have to make in order to implement a proper preventive ODR. And the key to solving this is having technologies that actually are aimed to preventing disputes. So I'm going to mention 4 of them, but I think there are many more that we can think of. But as long as we have a preventive approach, we can also get better results. The first one, and that's the boom that everyone's talking about, artificial intelligence, particularly AI agents or AI advice in real time. So what we're gonna do as a company or as a government agency or even as a board is that you're gonna give constant information to users so they can know how to react and how to interact with this kind of platforms and avoid those pitfalls that usually end up in conflict or in a claim in some kind of disagreement with the company they're dealing with. Second, process automation, and this deals a lot with legal operation as such. And then I can give you an example. In Colombia, recently, Cabify was having a lot of complaints of drivers that were charging for the ride without the passenger. So they were charging, but the passenger was not in the car, and there was a lot of disputes coming along with that behavior. So what happened before in their operations is that the person had to file, they had to submit a claim for the reimbursement of, say, $1 that they were charged for this automated banking charge. And then when you file for it, then you will have to apply to the bank, then you'll have to do some paperwork, and perhaps after 1 or 2 months, the consumer will be reimbursed. The consumer is not patient anymore. As I was telling you, people are using more and more e-commerce, so they started to go directly to the Consumer Protection Agency, in Colombia's case, the Superintendency of Industry and Commerce, and they were wasting a lot of money and effort with the Government Protection Superintendency. Well, what they did is that they automated one process, the reimbursement. So the reimbursement was automatic when the consumer was requesting it. So they changed the operation just a little bit. They automated that part of the process. And only with that, they start to prevent a lot of disputes. So then it's not necessarily using platforms, but also changing processes, automating processes. It's a very powerful tool for ODPR, online dispute prevention and resolution. A third way of avoiding conflicts is to improving cybersecurity or the security for communication platforms. One of the many sources of disputes in 2024 is the breach of information and habeas data claims. So what happens when the platform I'm working with is getting some information out of my personal data? So what I want to do, I want to avoid as many conflicts as I can. So I improve my security, I take preventive measures, and cybersecurity is also a way of preventing disputes. And as I was mentioning before, and this will apply to the 4 of these tools, it will apply the data monitoring or data analysis. The more data you have of the consumers interacting with your platform, the more data you have on their behavior, the more data you have on how people are actually getting angry, what's really going on with the users, then the better you get at having early decision-making processes and preventing disputes. So you see, some of them may apply to the platform as such, but some of them apply to the company. So how you can improve your operation as a company with the notion of legal operations. The better legal operations you have, the more you get the lawyers involved in the actual operation of the company, the better your preventive ODR is going to be. And then for the challenges, Of course, we love ODR. We talk about ODR all the time, and we know that this is the present and the future of justice. But there's still some resistance. The cultural acceptance on ODR alone is not sufficient yet. Imagine having preventive ODR. People just really don't know. They don't have this culture yet. So part of our work, having this kind of opportunities, is to getting more cultural acceptance. If you have the legal teams of a company, of a public agency, working on how to prevent disputes, you're going to have much better outcomes in the future. That comes along with the culture of legal operations, but also with the culture of trying to embrace technologies, trying to embrace data analysis, trying to embrace better early automated negotiation systems. The second is regulation. So dealing with cybersecurity, dealing with data or personal data, dealing with the consumer needs, the ever-changing needs of the consumer is very hard. And if the regulation is too strict, as you may notice, for instance, with the GDPR in the European Union, or with some legislations around Latin America, then it becomes increasingly difficult to try and implement these kind of systems. If I cannot do data analytics due to a very stringent regulation, I cannot help my consumers. And this is what's really paradoxical. The regulation is made to actually improve consumers' lives. But unfortunately, if the regulation is too strict, then you're going to restrict also the rights of the consumers. And finally, the data privacy and security, it's a challenge because you're going to get more and more information, and handling it will get harder or increasingly harder over time. As you know, this is a race. So the more cybersecurity I have, the more cyber hacking I will get. So it will be a continuous race, and of course, it will be more difficult over time, as we've experienced since the early 19th. So now our hackers are much more sophisticated, and we have to have much better defense tools. So it's like this race for the arms on how you can really try and do this. And finally, let me tell you, and this may sound very theoretical, but we've done this at Redec, the company I'm leading since 2021. We are also trying to implement preventive ODR, and this we are doing with the Energy Group of Bogota. We were hired at the end of 2022, not to go beyond dispute resolution. The Energy Group of Bogota, let me give you some context. The Energy Group of Bogota is one of the main Latin multinationals. It's a Colombian multinational that operates in Guatemala, in Brazil, in Peru, in Ecuador, in Colombia. So they have a lot of internal relationships between the legal management teams of all of these subsidiaries and the parent company, in this case, the Energy Group of Bogota. The communication was not that good between those affiliates and the mother company. It was very difficult at occasions. So what we're now implementing, we're not done yet, but we're now implementing is legal design applied to the needs of the Energy Group of Bogota. And we have a 3-module ODR that starts with those red and yellow flags, as we were mentioning before. We have this identification of risk and alarm module. So the first module, what you get is risks that will be analyzed from many data, of course provided by the company, and it will be an automated identification of risks on the basis of artificial intelligence. So we use ODR, and we use preventive ODR with artificial intelligence to get the risk wherever they are. So let me give you an example. If I'm one of the Brazilian companies affiliated with the Colombian mother company, then I may make a report where I don't highlight the risk. But the artificial intelligence reads the document, and since I already given it some AI prompts, identify risk and will report it to the legal vice presidency in Bogota. And the legal vice presidency, with that report, automated report, will make the decision on whether to follow up on the risk or not. So that will be the first module. The second module, module number 2, is the follow up. And then you get everyone involved, all of the stakeholders, so say the legal vice presidency in Bogota and the legal management team in Brazil. So they will start to talk to each other through an ODR platform, the REDEC platform, and try to see, okay, this is the risk, so these are the actions that we should do, and this is the policy that we're going to take, and we're going to escalate this to person A and B from the directive team, from the board of directors, in order to make a decision and not to have litigation in the future. But then there's a third module, which is properly ODR, because then it's when, even though you follow step 1 and 2, so you made risk identification and risk follow-up, the risk was finally consummated. So you really had a risk that was completed into litigation. So module 3 allows you to manage conflict, dispute that has already arisen, and then you will have dispute resolution. So you will manage the conflict there, you may be able to negotiate, or if not, you will have all of the information from the litigation that is associated to that risk. So module 3 basically operates when you fail to prevent in modules 1 and 2, but it has huge impact on what we want to do. And the way, this is going to work, this is going to change companies and government agencies' lives. Because what we see now, it's a lot of miscommunication, a lot of paperwork, a lot of information that goes through WhatsApp or papers or, many other means of communication. What we want to do is to make it more calm. And if you have a calmer environment, you will have better results because you are not in the business of reacting to disputes, but in the business of preventing them. And then so you can check what many other people have said about this, including Mr. Colin Roos, Ethan Katz, David Carneiro. So there's a lot of bibliography on this, and I believe this is the latest trend. This is where we're going. Thank you very much, everyone. I'm very happy to listen to your questions and to interacting with you as much as you want.
Thank you very much, Nicolas. And I put in the chat box that we'll take questions and people could drop their questions in the chat box, but I don't see any. I don't know if anyone wants to speak. You can just indicate by raising up your hand so that you can join the conversation.
I can start if you wish.
Oh, okay. Go on, Mires. Thank you.
Thank you very much, Nicola, for the presentation. I can only support everything you said because prevention is unfortunately not at the center of preoccupation of the professionals because it's not money generating. You need to be realistic with this. But it's really for the parties to be well informed about the techniques that exist, about the softwares that exist, about the other possibilities. I have been speaking very often about ombudsmen and about mediation because they are really underrepresented. And I think also prevention is very much underrepresented. And it really needs to be disseminated. We need to educate people to other roads that they can travel and stop really the conflicts before it escalates, as you mentioned. And prevention is really very important. But again, it's a question of simply informing and making users know that there are other techniques and that softwares exist. I didn't know about these 3 options that you presented, which I thought was very interesting. So once again, it's something that I think that users and parties in general, if we speak about parties in international contracts, business contracts, need to learn about and need to avoid, because we know that unfortunately since the lockdown, the economy has drastically changed, and even big companies need to look into the funding of dispute resolution. And if they know that there are other roads and a platform exists offering options that may help them, not only prevent the dispute, but save money and save time, it might be helpful. Now, the problem that we know, because most of us have started over 2 decades ago, and every time, unfortunately, I have been, like many others, disappointed to see that the business and the governments do not follow up, is because everyone is afraid and think it's science fiction, which is not. Because when projects are interrupted, they think that it was simply a test, a pilot test, and then it didn't work and everything stopped. So nobody finds confidence into using these platforms. And I think that this is really the biggest mistake that everyone has done for over 2 decades: stop, interrupt programs and platforms which were in place, giving the impression that nothing works. So I really hope that your proposal and your platform works, because this is definitely something that everyone needs, the consumers, the professionals. I encourage you to really disseminate and educate users. I don't know how we could do more, but I think it's really for the governments, the professionals, the organizations, the schools, the universities. It's everyone's business to promote these aspects. So sorry for having been long, but Nicolas.
Yes.
Yes.
Yes. So no, I fully agree with you, Maris, and I think sometimes I believe that the fact that ODR is called resolution, so people tend to overlook what really prevention looks like. But I believe the current trend goes to prevention. When we started to discuss with the Energy Group of Bogota, with them back in 2022, they said, okay, well, we don't need dispute resolution. Most of our disputes we're solving courts, but that's not what we need the technology for. We need the technology to better manage our relationships with our subsidiaries all around Latin America. And then we said, well, yeah, of course, ODR is made for that. So we can, and what we did, Mires, in that sense, is that we adapted a regular ODR platform with mediation, with arbitration, and we try to make it modular. So if you have 3 modules, it will be easier for people to realize how useful it will be. And they're really excited. They said, okay, this is different. And I agree with you. We have to talk more about this. And I think there's a huge business opportunity. I believe every single company, every single consumer protection agency needs to hear about this, and they will have a lot of even much better results than with regular or traditional ODR.
Definitely, and governments too. So
governments as well.
Yeah, public structures. Yeah, thank you, Nicola.
Yes.
And Mires, if you remember, we had a platform in Nigeria by the Federal Competition Consumer Protection Agency that was a platform that was more of, the disputes would have arisen, but the disputes were mitigated and they were reduced, because what happened on that platform was immediately the consumer complained, you found that the seller, the retailer, settled with the consumer. So the disputes did not escalate, unlike if that platform was not in existence and the dispute was allowed to fester, and then people will get entrenched in their positions, and then there'll be a lot of course, then we'll lose all of the benefits of the cost, the time that Nicola has already told us about. So we've had something like that. Unfortunately, that platform is no more on. Exactly what you said.
Very unfortunately. And most of the platforms that I promoted and mentioned in my various articles, all of them have interrupted their services. It's so disappointing, because you put hope in all these offers, and then people tell you saw that it doesn't work, nothing works. But it does work, but you need to believe in it, and you need to have funders who fund such projects believe in it and look into it into the middle and long term, and not only as revenue generating at the short term. This is the second biggest mistake. So not to believe in it and not to take it forward on a long term, on a long run.
Okay, Daniel says, thank you for your presentation. How do we go about marketing your services? Well, probably he's interested in marketing it with you.
Yeah, well, all right. Well, so, but I would like, before I go into Daniel's question, I would like to add on to what Mires was just saying before. I believe the the way people are perceiving ODR over the last few years is just okay. This is the last mile of our work, the last mile of the company, and sometimes they didn't even want to do anything with it. So it will be the legal team who will be in charge of managing the ODR platform, or they will have the third-party ODR provider. With this, and when I was mentioning cultural acceptance, it really becomes your tool, and that's why it has to be customized. You have to make it tailor-made. You cannot have it, completely open and completely or with that like one size fits all kind of approach. You need a particular approach to how your company works, because if you don't get this adherence, if you don't get people really using it, starting with your own lawyers, then it's useless. You're not going to get any results, and actually it's going to be an expense. It's going to be way more expensive, but you're not getting the results that you're looking for. So even more so than regular ODR, with ODPR, you need a lot more internal encouragement and internal motivation. And getting into Daniel's question, of course, I mean, I'm always open to looking into ways for marketing services, perhaps in Africa. So I'm more than happy to speak to you. But yes, so the way we are trying to market internationally is through alliances, and basically internationally we are working on advice and consulting services. So just so you know, due to this kind of presentations, not only here for ODR Africa, but in Prague a few months ago. So we were called by the Monetary Authority of Singapore. They wanted to find out and how you can apply preventive ODR for ESG, for corporate governance and sustainability. So this corporate social responsibility and sustainability, it's a lot of risk prevention, risk mitigation, risk management. So this is, of course, huge ODPR. Just if prevention is key to, for instance, prevent climate change or prevent disputes with communities. So the better mechanisms you have, the better results and the better openness of people you're going to get.
So it's basically the engagement of those who will be affected by the disputes that is paramount, because that's what allows you to then find the tailor-made platforms or develop the tailor-made platforms to address the different issues. Mires has advised that you please provide the URL to Redex, and we can put that in the chat box so that everyone can see what you've been doing, get a glimpse of it, and probably understand it better and see how they can at least plug into all of the work that you're doing. And where possible, make a referral or start to think of how, in whatever industry they find themselves, they can prevent disputes. Because what I've also found out is that sometimes, so we have the URL in the chat box, please, everyone. What I've found out is that sometimes not being able to understand the business will not allow you to do what you need to do for the company. Because just like we have like the three-tier multi-tiered dispute resolution clause in agreements, if we actually address, when we're even getting into contracts, ways that you can use technology to prevent dispute resolution. So you can have references to triggers in your agreement that allows you put the ODPR system in your structure. So that way, when something happens, it triggers, and then you are able to deal with it rather than allow it fester and get the parties entrenched in their positions.
Thank you. Thank you. Hello?
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 Yeah.
Yes,
Hello.
thank you. Thank you very much. Thank you, Nicholas. In Africa, I think the biggest thing that we have, and I think that's what Mireta was referring to. Sometimes, unfortunately, and I think it's also the same in maybe Latin America, not so much here in the US. The government system are totally not in line with what the public want. So sometimes you end up with a lot of bottlenecks that come not because there is any benefit to anybody, but because of the power. So most of our leaders don't really connect with the needs of the people. So corruption become a very big issue. Now, here in the United States, it's a little bit different because we do ADR, we do, they even have this court-ordered mediation where the judges now are saying, when you go to court, before I deal with your case, I want you to go into mediation. If you agree, we'll get that statement, we will file it and becomes a record. Now, if you don't agree, you come back to me as a judge, and now you're giving me power to do it. Unfortunately, back in our countries, ADR, or even, it has not taken in to people. People don't understand it. Even here in the United States, you still see people who don't understand mediation, who don't understand that you don't necessarily have to go to a lawyer. You can still resolve your issue within here. And I'm looking at this and I'm saying maybe the first thing you need to start is with the private organization, because when people see in private organization, they're able to resolve their own dispute without necessarily bringing in the government. I think the general public will slowly begin to take it, and our politicians will see the need for that. Because the issue, and you talked about regulation, which is very important, because if there is no regulation, it will be meaningless. But I think that is where a lot of us get stuck, especially in developing countries. There is still, that thing has not come out to understand that we are saving money, it is more efficient, and we don't have to go through all this pain people go through. And I don't know how you handle that, as maybe in Latin America or wherever you operate.
All right, I think that, Daniel, that's so a very good question, and I think it really connects to what Monique just said. Let's start with Monique's point, because I think there. Can you hear me? Okay. Can you hear me?
Yeah, go on. We can hear.
Okay. So I was so of course you can have it as your own internal tool. So that's what I see that the Energy Group of Bogota is doing. If it's your own internal tool, then you need only to get the acceptance of the members of your organization. It's a matter of corporate culture, right? So then the effort is big. It's a challenge, of course. Cultural acceptance is a challenge. But then if you manage to get your team aligned with your purpose, that you don't want to have as many conflicts, then you're going to achieve the result. But then there's the second layer to this. So if it's just prevention, so you do risk management through ODR platforms. But then if you go to the second step, and I think that's where Daniel points, and also Monique's points becomes very relevant, is how do you manage in a relationship between two organizations when you have a contract? And then if it's a challenge to have an ODR clause, how can you even now implement preventive approach? So do you have to have an extra layer of contract clauses, or extra ADR regulation in order to make prevention? And I think that's correct in a sense. I've only worked on implementation of one prevention just involving one company. But if one of the companies is conscious enough that it will lead to higher savings of time and money and effort, I believe it will be easier to convince the other party to hop along and try to get a preventive approach. So I know what you're also saying, in Colombia, it's also a challenge for people to accept mediation or arbitration as alternative dispute resolution mechanisms. But if you do the effort of going through an ADR clause, which I understand it's already difficult, well, go ahead, do the extra effort to get the preventive approach. So it will be probably a different kind of clause. It will be perhaps a bit longer, we with an additional layer of how you're going to prevent conflict, but it would lead to better outcomes. And what we were presenting in Prague back in June, it was a pity that we did not see each other then, but when we were trying to apply it to climate change or to continuous relationship agreements, say, for instance, I'm an oil platform and I'm providing, I'm making an oil supply over the course of 10 years to have a lot of environmental risk, and I have a lot of climate change risks associated to this. Then we could actually implement this kind of online dispute boards, which is a mechanism that goes beyond mediation or arbitration, but you have a board or some people that will, a sort of tribunal, but permanent tribunal, that will look into the relationship over time, and they will be able to follow it up. So for this consulting work that we did for the Monetary Authority of Singapore, we mentioned that. So having online dispute boards, so having people that will be able to look into the risks over time, continuously, perhaps that would reduce this transaction cost that you're mentioning. But if you have to educate on ODR, you will have to educate about ODPR. And you have to do both things. But if you're going to do one, well, why not do the two layers anyway? So that will be my approach. So try and do it anyway, because I think it leads to more savings. It leads to better results.
Thank you, Nicolas. Numerez wants to say something. You have the floor.
It's only about the REDEC platform. Please correct me if I'm wrong. You're speaking about a project which is not yet promoted on the platform, because I see no words related to prevention, and I think that is important, because you only speak about dispute resolution.
No, you're absolutely right. So that's the thing. So we had this website since the very opening of the company, but we are in the process of changing it. And of course, we're gonna mention the GEB, the Grupo Energía Bogotá platform, in the way that you're saying. And the thing is that sometimes you get caught in work, and then you don't look into the proper promotion and marketing. But yeah, that's something that I really need to do, and we're working on it with our communications team.
Okay, because this is really the added value that your service is bringing, and so I thought it was important to highlight it. Thank you.
No, yes, absolutely right. Thank you, Mirez, for the suggestion.
Thank you, Mirez, for that. Do we have? Okay, so Daniel, just to correct you, we actually have a lot of countries in Africa that have mandatory court-referred mediation. Particularly, it's quite strong in Nigeria, and the Lagos Multi-Door Courthouse is the first court-connected ADR center in Africa. And Lagos State, I know Lagos State, Abuja, like a few other states in Nigeria, actually have included in their rules of court mandatory litigation ADR steps that you have to take, the protocols in place. And if you have not gone through all of the protocols to do a mediation, the courts will not even allow you proceed with the hearing. So everything you file is screened through the court system. And if it is suited for mediation, you are referred to. It's mandatory. Of course, when we say mandatory mediation, nobody can force you to settle, but you are just mandated at least to sit on the table with the other party on the other side and see how the matter can be resolved. So we're moving on in Africa, and we'll get there, Daniel. Don't worry about it. And
we have it in Kenya also, because the other day we had a conference, an international conference, and the Chief Justice of Kenya also attended that. She was actually the main speaker. So it's coming. And one of the challenges that came up is is this thing. They were saying you make an agreement with somebody, you have been in mediation, and then somebody somehow turns around and say, I was never even there. I didn't even sign this, and it's like, how do you now even help them? Because somebody went back and somebody convinced them, oh, you know what? I think you should not have signed that document. And this is what the Chief Justice was saying. Those are some of the challenges they are seeing, where people still have not understood that you don't need to manipulate the system. We have to find out how we can teach people to accept what is happening, because I think there is this mentality, and I don't know, Nicolas, you have it in Colombia, and especially in Africa. If somebody is always thinking somebody is trying to hoodwink me, somebody is lying to me, so I need to find an alternative. So the alternative becomes an alternative, and it's never settled. So I think it's a matter of educating people, where now you let people get educated, because even here in the US, there are still people who don't even understand what is mediation. When they are sent to the court and go for what is that? They are thinking is meditation, So I think the good news is it is becoming slowly accepted by people. People are beginning to accept it. But I think we have to keep on educating the people. We have to keep on talking about it. We have to keep on giving presentation. We have to start talking probably in our schools and in our universities, so that the Gen Z are the ones who are really going to adopt this thing, because they are so much online. And I think the opportunity is there, but we have to keep on pushing it.
Well, I know that in a lot of African universities now, we have mediation, arbitration, and ADR taught. And recently, we had a competition for universities, Odr Africa Network, in conjunction with INADR, for universities across Africa. And it was a mediation tournament. And so the culture just has to change. It will take time. It's evolving, but it will take time. And with much more education and cultural reorientation. So the essence is not for people to stay focused on one route, but to show that there's so many routes to achieving resolutions and justice, and increasing access to justice for parties in conflict. Nicolas, I think you had your hands up. You wanted to say something.
Yes. No. I think what you're saying is actually very accurate, and it's necessary. As we've mentioned before, education is key to making this work. But I would say that having mandatory mediation, I would say also as a parenthesis that meditation works to prevent conflicts. So meditation, that should be also a mechanism. But jokes aside, when it comes to mandatory mediation in Colombia, we have this procedural requirement. In order for you to go to civil courts, it's mandatory that you do, in Colombia we call it conciliation, like a sort of a regulated mediation first. However, I believe that prevention ODR goes beyond mandatory mediation. Because at the end, to me, mandatory mediation, if it's online, it's ODR, it's resolution. The conflict has already arisen, it's already existing conflict, and then before it goes to court, you use ODR, which is perfect. So in a way, it prevents litigation, but it doesn't prevent the conflict as such. The conflict already exists. So my point is that we have to look into risks. A risk prevention approach, having lawyers as risk managers with the use of technologies, that's what's really going to make the difference. And then having it as part of the corporate culture, but also as part of university education, as a part of the legal system as a whole, the government, everyone, the more they try and implement it, the more people are going to be excited about this and are really gonna use it. But yes, of course, having mandatory mediation is excellent, but we can go way beyond that. We can do a lot more good stuff with what we have.
Thank you very much, Nicolas. Do we have any other questions or comments? We have just a few minutes left to the end of the session. If not, I'm going to ask Mires, who is the chair of the ODR Africa Advisory Board, to please say thank you to Nicolas and to everyone who has taken time to be here with us today. Mires, over to you, please.
Thank you, Morenike. So, Nicolas, I can only encourage you to continue and not to stop this project, because I think that with your multidisciplinary experience, you can bring it forward. And you just need to continue also convincing those supporting or funding the project that it will work, provided everyone keeps on believing and funding and promoting the project. So good luck, and we all support. And I think that Daniel is also in agreement with this, Morenike, and all those who see on the ground how it happens. Thank you very much.
Thank
Yes,
you.
Monique, thank you very much. Really appreciate it.
Thank you, everyone. So
Thanks, everyone.
it would be good morning, good afternoon, good evening, wherever in the world you are. Thank you very much. I think this has been a very educating session for all of us. And we look forward to more education and all to doing the education about ODR in preventing disputes. Thank you and bye for now.
Thank
Bye.
you.
Bye.